Good morning, everybody, and welcome to another UKDEA webinar. We're just waiting for the room to fill up. We've got about 200 people registered this morning, and there's lots of people joining us. Although it might say Tom Woodward at the bottom of the screen, my name is actually Simon Woodward. Tom's on holiday today and left me to run this. So I am chairman of the UK District Energy Association, and I will be giving a brief introduction to the UKDEA. Before I hand over to Laura and Bethan from Bevan, Brittan, to talk in detail about the Procurement Act 2023. At the bottom of the screen, you will find two little icons. One is questions and one is chat. You're welcome to put anything you want into the chat. Say hello, be friendly, and but if you've got a question, please put that into the question tab at the bottom of the screen. So just ask any question. So I'll just put one in there. So I'll say hello, and there we go. So if you want to post a question, please do. Okay, without further ado, I will move on with a brief introduction of the UKDEA. So as I said, my name is Simon Woodward. I am the chairman. The topic for today is the Procurement Act 2023. The main speakers are Bevan Brittans, who will be joining us shortly. If you haven't heard of the UKDEA before, we were formed 15 years ago. We were formed by 6 founder members, largely local authority organisations, who wanted a voice for heat networks in the UK. And to be a full member, you must own or control a scheme. Those were the full founder members. The logos you can see at the bottom of the slide, they're the current full members, so largely the major energy services companies in the UK. But we have a whole host of very important associate members, ranging from consultants advisors such as Bevan Brittan, installers, equipment suppliers, educational service providers, and interested local authorities. And all members are equal in their importance to us. So lots of benefits of joining UKDEA. I'll just run you quickly through them before I hand over to Bevan's. While people join the room. Benefit number one is the collective network. We have 170 members. So communicating with 600 individuals. We've got roughly split 50-50 between 50% are either selling an item of equipment or advising, so consultants, legal advisors, manufacturers, system suppliers, and the other 50% are either local authorities, local authority energy services companies, or energy services companies and contractors. Benefit number two, so each month we publish a monthly journal. That goes out to all of our members. It's a two-way street, so it's both a place where you can find out what's going on in the world of heat networks, but also talk to people about your product and service if you operate in the private sector. Benefit number three, UKDEA website. This is sort of the hub of everything going on. It talks about what our members are, what webinars we've run, the document library, lots of different things. So an important information source for all members. Benefit number four, member meetings and contact with DESNES. You're very welcome once you've joined to contact me, contact Tom, and we'll happily have a meeting with you whenever you want. We're a free source of what's happening in the sector, and because we're kind of the hub of heat networks, we generally know what's going on. As long as it's in the public domain, we can talk to you about it. And we meet monthly and often weekly with officials from DESNES, so we're very close to policy evolving policy, and we can keep you involved. And there's a nice attestation there at the bottom of the screen from Jodie Pittaway, who runs the Scottish and Southern Heat Networks business. Benefit number five, we have a number of working groups where members get together and discuss key topics ranging from sleeving, so transferring low carbon heat across high carbon heat networks, counterfactuals, so how prices should be set, the supply chain, heat network zoning, and we're just setting a very important one up on the public sector decarbonisation scheme. And how we can make that work for heat networks. We also respond to all relevant consultations. We're just in the process of responding to the latest Ofgem consultation on fair pricing. Webinars, so as per today, we run a number of webinars. Generally they're CPD certified. We run them on a range of topics. Please do sign up for them. We're running another one in a few weeks' time. We're looking at funding and financing heat networks, which may well be of interest to many of you on the at the event today, but we've also looked at more technical things such as applications of heat pump, system sufficiency, and utilising waste heat in the heat network. So, but all of those, as per the one today, will be on the UKDEA YouTube channel. In-person events, we run typically 2 in-person events each year. We take place at Future Build at the Excel Exhibition Centre in March, where we have a heat network zone. That's the top image. The bottom image, we're really excited. We had a conference. We typically have a conference once a year with a small exhibition. The last one was at Alexandra Palace in 2023 with 230 delegates, 30 exhibitors. This year, we're targeting 400 delegates and 50 exhibitors, so really exciting. That's on the 7th of July. If you'd like to find out more, please do contact us. The details are at the end of the presentation. And we're doing that in partnership with DESNES, so very excited about that. They're putting some money into the event, so that'll be the largest ever Heat Networks conference and exhibition in the UK. So very excited about that. Training register, if you want to get sort of detailed technical training in the world of heat networks, there's a good training guide on our website. Please do visit that. It fits under sector resources. Jobs board, once you remember, you can advertise any vacancies for free, whether you're public or private sector. We get a lot of traffic going through the website, so it's a good way for advertising jobs. Podcasts, we've got a number of podcasts which are live, and we've got some interesting ones coming up as well. Please do look out for those. They're on all major podcast channels, and some really interesting topics. The last one we published was looking at customer engagement and how to engage with customers and make them want heat networks. So that was a really interesting podcast. Benefit number 11, UKDEA awards. So we will be publishing details for all members. For the UKDEA awards, we'll be handing out at the conference in 2025. So that'll be on the 7th of July. So please look out for details of the awards. Benefit number 12. We've launched earlier this year a heat network specifiers guide. Again, that's on our website. So that lists everybody. It's a who's who of heat networks. So where you can go to for advice or for systems or for people to build your scheme. All of our members are there in the heat networks guide. Again, it's free. It's available from our website. And then finally, just before I hand over to Laura and Bethan from Bevan's, there's my details at the bottom of the screen. The slides will be circulated to everybody who's registered to the event. Please do get in contact if you'd like to join. It's a fairly nominal fee for associate members, which will be most of those people on the call, just over £1,000 a year. And for full membership, it's around £2,000 a year. So some quite attractive membership fees. And as I say, we've got about 170 members. It's a really exciting and rapidly growing sector association. So without further ado, I will pull my presentation offline and I will bring up Bethan and Laura's presentation, and I will ask them to come and join me on the stage. And I will hand over to Bethan and Laura. Okay, so if you'd just like to say something both, and then I can make sure you're on live. Hello.
Hello everyone.
Brilliant. Excellent. Okay, well, I'll allow you to introduce yourselves. I will leave the stage and I'll leave you to listen to Bethan and Laura. Thanks very much indeed.
Lovely. Thank you very much, Simon, and hello everyone. Thank you for inviting us to do this and for coming along to the session. To introduce myself, I'm Laura Brealey. I'm a partner at Bevan Brittan. My specialism is procurement and specifically procurement litigation. So I most commonly come into procurement processes either right at the end when there's perhaps a losing bidder who's upset at the outcome, but also sometimes during procurement processes when perhaps a risk issue is identified and either a local authority or a supplier wants some advice on how to manage it. I'd also like to introduce my colleague Bethan Lloyd. Bethan is a procurement specialist partner at Bevan Brittan, and Bethan operates sort of at the other end of the scale to myself. So she would most commonly work on structuring procurements and making sure they run smoothly during that process. So in terms of the session today, we want to give you a bit of a whistle-stop tour through the Procurement Act. We can't cover absolutely everything, but we've picked out some what we think are key aspects that we think it would be good for you to know. So before I launch in, I just want to make you aware, if you Google search for ProAct 2023, that will pull up our Bevan Brittan free resources, and it's a useful repository of information. So you've got links to the Act, to the relevant regulations, and to the Cabinet Office guidance, and the learning manual, as well as our own webinars and articles that we've put out on the Procurement Act. So today we're going to look at 5 topics, and we've made them case study based to hopefully bring them to life. The first topic will be looking at who is a contracting authority, so who do the rules apply to. We will then look at what exemptions are available, and particularly those that we think are most relevant to those who operate in the district energy sector. Given that the Procurement Act only came into force in February, we're still in what we could regard as a sort of unofficial transition stage. So in some instances, we are grappling with both the new Procurement Act, but we can't put the old system to one side completely. So we have a case study around which set of procurement rules apply. Then we will look at a case study on direct awards, and through this we will sort of bring to life the fact that there are actually quite a lot more notices that contracting authorities have to publish in relation to procurements than perhaps we were previously used to. And then in topic 5, we'll look at what we need to think about now in terms of contract management, given that the Procurement Act applies to contracts even after they've been signed. And that is quite a difference from the previous regime. So that, I think, will take us up to about 11:30, and then there will be about 10 minutes for a Q&A at the end. So do please post questions in the questions tab, and we will probably pick those up at the end rather than as we're going along. So in terms of topic 1, am I a contracting authority? So I'd just like you to assume that you are a contracts manager within a local authority, a big town council, and you have a question for your procurement officer. So you've said, good morning, I've heard that all the procurement rules have been consolidated into the new Procurement Act and that it covers entities who are contracting authorities. What does this mean for us, the council, and also what does it mean for our wholly owned district heat network operator, DHN Limited? Are we both covered by the Procurement Act? Many thanks, John. So John is correct that all the procurement rules have now been consolidated into the new Procurement Act. So previously we had different regulations covering public sector contracting. So we had the public contracts regulations, and then we had different sets of regulations covering procurement related to utilities activities and other types of contracts. And one objective in reforming the procurement rules was to simplify the multitude of legislation into one act, the Procurement Act. So that is what has been done, but whether it in fact results in a simplification is open to debate, but it is correct that the rules are at least now under one umbrella. So the Act governs the procurement activities of contracting authorities, which is a term that many of you, not most of you, will already be familiar with. And it will come as no surprise to you that public authorities, such as central government, local government, NHS trusts, for example, are contracting authorities whose procurement activities are covered by the Act. Nothing of substance has changed in that respect. And that part of John's question is simple to answer. So what about the council's wholly owned subsidiary, DHN Limited? So to answer John's question, the procurement officer of Big Town Council will need to have a closer look at what types of entities are contracting authorities. And for those of you who do need to navigate your way around the Act, your starting point is Section 2 of the Act. And this states that a contracting authority is a public authority, but if you are procuring a utilities contract, then public undertakings and private utilities are also contracting authorities. So let's have a look at whether DHN falls within any of those categories. So firstly, is DHN Limited a public authority? A public authority is an entity that is wholly or mainly public funded or is subject to public authority oversight. And in addition to be a public authority, DHN must generally not operate on a commercial basis. So we're looking at something that's really quite public in nature. So in terms of John's question, we don't know how DHN is funded, and we would need some more information from John on how it is structured and how it operates in practice. But as it is wholly owned by the council, it is quite likely in this scenario that it will be subject to management and control of Big Town Council, or that its board will be predominantly appointed by the council. And in that case, it would be subject to public authority oversight. In terms of whether DHN operates on a commercial basis, again, we haven't been given enough information in John's email to know for certain, but the sorts of things that would be relevant here are if, for example, Big Town Council props up DHN, if DHN were to make a loss, or if DHN, by virtue of its relationship with the council, is able to contract on favourable terms, and if the market in which DHN operates is not subject to fair competition, then those are all factors that would point towards it not operating on a commercial basis. If, perhaps which is more likely, DHN does operate commercially, then in this scenario, it will likely be a public undertaking. So public undertakings are entities which are subject to public authority oversight, so subject to management and control, and which do operate on a commercial basis. So I think we've got a situation here where DHN is likely either a public authority or a public undertaking. And in the context of utilities contracts, the rules that apply to public authorities and public undertakings in the Procurement Act are in fact very similar indeed. There are some subtle differences in the way that some of the exemptions apply, but generally speaking, the rules applicable to both public authorities or public undertakings who are awarding a utilities contract are largely the same. So the important point is that if we're satisfied that DHN is either a public authority or a public undertaking, most of its procurement activities in awarding utilities contracts will be covered by the Act. Now, the third possibility, just to consider for completeness, is whether DHN, or whichever entity you're looking at, is a private utility. Private utilities are entities who are not public authorities or public undertakings, so may, for example, have no public sector ownership or oversight, but who do carry out a utility activity pursuant to a special or exclusive right, so for example, in some sort of monopoly type situation. So as we've seen in the example that we're looking at, DHN would probably be either a public authority or a public undertaking. So it's unlikely in our particular case study to be a private utility. However, it is worth being aware that there are a number of provisions of the Procurement Act that don't apply to private utilities. So they just have a lot more flexibility in what they can do in terms of procurement. And that really reflects the situation as well that we had under the previous regime. So notably, for example, the obligations on private utilities to publish notices and information at various stages through various stages of a procurement are far less onerous. So let's just have a quick look at what we mean by utilities contract and utility activity. So a utilities contract is a contract for the supply of goods, services or works, wholly or mainly for the purpose of a utility activity. And the utilities activities that are most relevant to district energy projects are found in Schedule 4 of the Act. So activities connected with the provision or operation of gas or heat networks that provide a service to the public and the supply of gas or heat to those networks are covered. And then there's similar in relation to fixed networks for electricity. So going back to our example, we're told that DHN Limited is a district heat network operator. The operation of a district heat network is a utility activity, So the contracts that DHN enters into for the purpose of operating that network will be covered, subject to any exemptions. So just in quick summary, we know that Big Town Council is a contracting authority, and it appears highly likely that DHN is also a contracting authority in respect of the contracts that it enters into in order to operate its network. And to complete this picture, there's an abundance of terminology in the Act. We can also refer to DHN as a utility, and the definition of that is in section 35 of the Act. And on that note, I will hand over to Bethan for topic 2.
Thank you, Laura. Yes, so topic 2. So here we're going to look at the scope for direct awarding utilities contracts rather than running a competition to award them. So another project officer, Rhian, has emailed, and it's still about DHN. And she's telling us that DHN is about to build a new heat network in Warm Vale Town Centre. And she's asking what scope there might be for DHN to direct award contracts in connection with that project rather than run a competition. So what options are available for Rhian here? So I'm going to suggest that we stand back and look at this through a broader lens, first of all, because there are 4 options to explore, really. First of all, she could consider whether any of the contracts are below threshold. So the Act only requires a competition for above threshold contracts. So it doesn't prevent the direct award of below threshold contracts. But there is a but, and DHN will still need to check that the local authority hasn't restricted its ability to direct award below threshold contracts. So local authority procurement policies often still require a competition for below threshold contracts if they're worth more than a certain value, typically around £25,000. And in fact, it's not unusual for a local authority to require its wholly owned subsidiaries to also comply with that policy. So Rhian will need to check what the position is in that regard for DHN. A second possibility then might be for DHN to use a framework to make direct award of certain contracts. Now, if she wants to look at this, Rhian will need to check that DHN is able to buy from the framework in question, that the contracts it wants to award are within the scope of the framework, that the framework terms and the call-off contract terms are suitable for its requirements, and that the framework allows direct award, because that's not necessarily going to be the case. And even if it does allow direct awards of call-off contracts, you need to look at the mechanism for determining which supplier on the framework gets that contract. So that's something she might want to look at. But of course, a framework is a ready-made solution with ready-made contract terms by and large. So that might not be suitable for DHN if what it wants to do is very bespoke. So that's a broader picture, but I want to focus really on the third and fourth possibilities here on the slide. So if a contract is exempt, it doesn't need to be awarded in accordance with the Procurement Act at all. And so a direct award will be possible, subject to, as I've already mentioned, if the local authority has put extra controls in on DHN. And there may be scope to make a direct award if a direct award justification applies. So let's look at the exemptions first. They're found in Schedule 2 of the Act. I'm going to focus on those which are specific to utilities contracts, but don't forget that there are some general exemptions too, such as the TECL exemption, which of course was in the old rules and it's been replicated in the Act. But I have to say, in my experience, district heat companies set up by local authorities don't typically meet the conditions for TECL status because they tend to be market facing. But anyway, that's there. So if that was relevant, Rhian could make use of it for DHN. But moving on to the utility-specific exemptions. So we look at the ones in the top box first. And these 2 exemptions, they depend on the nature of the relationship between the utility, so DHN in this case, and the party to whom it wants to award the contract. Paragraph 5 replicates part of the Regulation 29 exemption in the Utilities Contracts Regulation, so in the old UCR. And it applies where there's a relevant joint venture. Now, that means a joint venture between 2 or more utilities to carry out a utility activity. It allows joint venture partners to direct award contracts to their joint venture, and the joint venture can direct award contracts back to the joint venture partners too. So this exemption could be relevant for DHN if its new heat network will be delivered as a joint venture with another utility. But there's nothing in Rhian's email to suggest that this is the case, so it's probably not going to apply here. The paragraph 6 exemption replicates the Regulation 29 exemption in the UCR, and it allows a utility to direct award contracts to its affiliated persons, provided they meet the turnover test. Now, an affiliated person, what does that mean? Well, it means any group undertaking of the utility. So this covers situations where there's a parent and subsidiary relationship between the utility and the affiliated person that it wants to award the contract to. So, for example, a holding company and a subsidiary. But it also covers a sibling relationship where the utility and the affiliated person are subsidiaries of the same parent company. And it's broader than that. It could also cover grandparent and grandchild relationships, cousin relationships, and so on, if you would excuse the family metaphor there, but I think it nicely describes this concept. So the members of a group of companies will usually all be affiliated persons of one another, but the concept of affiliated person is wider than that. It's not confined to a group of companies as such. It also would apply in the context of other types of organisation where there were those sort of parent, subsidiary or similar family type relationships. Now, to add to that, if the utilities of DHN in this case is also a relevant joint venture, so as I just mentioned in connection with the previous paragraph 5 exemption, that's a joint venture between utilities to carry out a utility activity jointly. Where that's the case, the paragraph 6 exemption also allows the joint venture to direct award contracts, not just to the joint venture partners, but also to the affiliated persons of those joint venture partners. It goes broader still. The paragraph 6 exemption only applies if the affiliated person satisfies the turnover test. That's important. It means that more than 80% of its turnover must be from supplying the utility and other affiliated persons of the activity. Sorry, of the utility. So the important thing to remember here is that the turnover test isn't assessed on the affiliated person's entire turnover. It's only on its turnover in supplying goods or services or works, depending on whether the contract to be awarded is for goods, services, or works. So, for example, if DHN wanted to use this exemption to direct award a works contract to one of its affiliated persons, then you'd run the turnover test on the affiliated person's turnover from carrying out works for DHN and DHN's affiliated persons to see whether more than 80% of the turnover was for that work. And the affiliated person will, of course, have affiliated persons of its own, and their turnover for the works or the goods or the services, as the case may be, can also count towards the 80% if they are themselves delivered for the same utility or affiliated person, so DHN in our example. So that's those 2 exemptions. I'm going down now to the second box, and these are the exemptions for utilities contracts that depend on the subject matter of the contract. So we've got paragraph 31. This replicates the existing Regulation 18 exemption in the UCR. And that applies to exempt utilities contracts awarded for the purpose of a sale or lease to third parties. but only if the utility doesn't have a special or exclusive right to sell or lease those goods, works or services, meaning that it's operating in competition with others. So that's paragraph 31. Then we've got paragraph 33. Again, this replicates an existing exemption, this time regulation 23 in the UCR. And this is a more important one, I think. It covers a utility's purchase of energy or fuel for the production of energy. So here, in Rhian's example, it would cover, for example, DHN's purchase of heat for its heat network, or its purchase of electricity, perhaps, to run its heat network. So I tend to find in practice that that's quite a useful exemption that tends to crop up in the heat network scenario. And then finally, I want to mention, and I didn't put it on the slide because it's not a utilities specific exemption, but it's worth remembering the exemption for the acquisition of land or buildings, or an interest or right in land or buildings. Now, if DHN is going to be perhaps buying little parcels of land or taking easements over land for its heat network, then it may well be that those contracts are exempt contracts because they only deal with the acquisition of a land interest. And that's assuming, of course, that they don't have tacked onto them an associated above threshold supply of works, goods or services. So those are the utility-specific exemptions. And as I said, there are some more general exemptions to consider as well, but I'm not covering those in detail. We've also got the direct award justifications, which may be relevant for DHN. So, and these apply to all types of contract. None of them are specific to utilities contracts. And none of them are new, in fact. They all replicate direct award grounds that were available under the old procurement rules. So we've got paragraph 5. This is where a particular supplier has intellectual property rights or other exclusive rights, and that means that only that supplier can deliver the contract and there are no reasonable alternatives. It's usually quite difficult to rely on this ground, and certainly under the old rules it was construed very narrowly by the courts. Interestingly, the government's guidance on the Act suggests that exclusive rights could arise from the ownership of land, meaning that the owner of the land has the right to determine which contractor can deliver works on its land. So this, if that's correct, then this might enable DHN here to direct award contracts, works contracts, for example, to landowners that it has to deal with in connection with its heat network. So, for example, if DHN needs to transact with a landowner to take an easement, and the landowner says, I'll give you this easement, but I'm going to insist that you award the works contract to dig the trenches, to lay the pipe in the ground. I'm going to insist you award that to my favourite contractor over here. Potentially, DHN could look at using this exemption to make that direct award on the basis that that landowner has exercised its exclusive rights. Then we've got paragraph 6. So this is where only a particular supplier can provide what's needed due to an absence of competition for technical reasons. And again, provided there are no reasonable alternatives. Now, again, we've got guidance on this. It gives some examples of where there might be an absence of competition for technical reasons. And they are where the supplier has specific know-how or tools for working on bespoke equipment, where there are interoperability or safety requirements to ensure the proper functioning of goods, works or services, and where there's an incompatibility with existing systems or equipment that would result in time-consuming or complex redesign and modification, which would be unacceptable in the circumstances and would result in significant cost or delay to an important service. So those are really very narrow examples there of where there might be a complete absence of competition. So again, as under the previous rules, this is a direct award justification that I think is going to continue to be construed quite narrowly by the courts. Moving on to paragraph 7, probably less relevant for DHS, that's sofas, isn't it? DHN at this point in time, because it's just getting started on this heat network project, I think. But this exemption, sorry, this direct award justification may be more relevant in the future. It applies where there's a need for additional or replacement goods, works or services, and they need to be the same or compatible with what's already been purchased. And a change in supplier at that stage would mean that there are differences or an incompatibility, and this would result in disproportionate technical difficulties in operation or maintenance. So that might be something for DHN to keep in its back pocket for future, but it's probably going to be less relevant when it's starting off its project. And then finally, section 43. So as under the previous rules, there would be the ability to switch to a direct award process if there'd already been a competition, and that competition resulted in either no suitable requests to participate at all, or it did go through to the bidding stage and there were no suitable tenders. So based on Rian's question, I don't think we've got that scenario here, but it's useful to know that that's available if it's needed. I put a reminder at the bottom of the slide here, which is that whatever direct award ground DHN uses, it's still going to be required to consider the excludable and excluded supplier grounds in the Act. And as well as that, if the party to whom it wants to make the direct award is an excluded supplier, that's not going to be permitted unless DHN can be satisfied that there are overriding public interest reasons for making that direct award to the excluded supplier. And those grounds for there being an overriding public interest are very narrow. They're set out in the Act, and I think they're rarely going to apply. So yeah, I mean, hopefully that's given Rian a range of options there for making her direct award. I'm going to move on now to topic 3, which looks at which set of procurement rules apply. Are we working under the old rules or are we working under the new rules? So the Procurement Act came into force on the 24th of February 2025. It's almost all in force now, but it doesn't apply across the board. As Laura mentioned earlier, there are transitional rules to determine whether it's the old rules or the new rules that apply. And here, again, it's a case example. We've got the local authority team receiving an email from Rena, and she's asked, she's got 3 contracts she wants to award or is dealing with, and she wants to know which set of rules apply for each of the 3 scenarios. So in considering Rena's email, the legal team is going to want to probably consult the Cabinet Office guidance on transitional and saving arrangements. This is useful. It summarises and gives guidance on the regulations that we've got that deal with the transition rules, and those are the regulations set out on the slide there. The rule is, the fundamental rule is that for procurements that commence, that's the important word, procurements that commenced before the 24th of February, when the Act came into force, are governed by the old rules. And procurements that commence on or after the 24th of February are governed by the Act. So a procurement commenced under the previous rules will continue to be governed by the previous rules. And that means that it's the previous rules that apply to any contract awarded as a result of that procurement exercise. So the key question here to answer Rena's queries is, what needs to have happened for a procurement to have commenced before the 24th of February? The answer to this, the detail on it, you'll find in the regulations, which are pictured on the previous slide. And I'm not going to go into all the nitty-gritty detail today. Just going to touch on some of the key points. So first of all, in relation to where there's been a competitive procurement exercise, of course, that is usually kicked off the contract notice, at least under the old rules. And if the contract notice was published before the 24th of February, then that procurement exercise will have commenced under the previous rules, and the previous rules will apply throughout the lifetime of that procurement. Now, sometimes contracts are awarded under a framework or a dynamic purchasing system, DPS, or a qualification system in the utilities context. And provided the procurement of that framework, DPS, or qualification system was itself commenced under the previous rules before 24th of February, then call-offs under that framework, DPS, or qualification system will also happen under the previous rules. What about a direct award? Well, again, we're looking at when that direct award procedure was commenced, and the rules say that that all depends on when the supplier was first contacted by the contracting authority for the purpose of starting the direct award process. I think that that's sometimes can be challenging to work out exactly when a direct award process has started. So there may be some challenges there. But what the rules do tell us is that the publication of a VET notice under the old rules before the 24th of February is an indication that the direct award process has commenced, because of course a VET notice is published into the market that you intend to award a contract. And so that'll be enough to show that the previous rules have been locked in. So, having that background in mind, let's return to Rena's 3 questions and see if we can answer them for her. So her first contract is a DBOM contract for a heat network, and it was advertised and entered into in 2015. And now she'd like to extend it by 3 years. So I'm going to assume it was an above threshold contract and that it was properly advertised back in 2015, probably would have been under the UCR, because she's told us that DHN is a utility. That being the case, the procurement for this contract would, of course, have commenced under the previous rules. And the extract on the slide there in the left-hand box, that's from the Cabinet Office guidance, that confirms, as indeed the legislation does, that contracts awarded under the previous legislation will continue to be managed under the previous regulations. So here, Rena was wanting to modify a contract that was awarded under the old rules. So she'll look at the rules on modifying contracts in the old rules. So here that will be Regulation 88 under the UCR. So that's fairly self-explanatory. Rena look at Regulation 88 to see whether one of the safe harbours for modifying that contract applies. And if it does, I mean, she'll be able to extend the contract. In terms of the notice requirements on her, she won't have to notify the market in advance that she wants to do the modification. But depending on which of the grounds of modification she wants to rely on, there may be a notice she has to publish after making the modification. And she's also got the option on a voluntary basis of publishing either a VET notice or a contract award notice. So that's her first. Her second query related to she wants to award a call-off contract under a consultancy services framework that was set up in 2023. So, so of course, that framework would have been set up under the previous rules. Now, again, we've got an extract from the guidance here, and this confirms, as I've already mentioned, contracts awarded under a framework agreement set up under the previous rules will continue to be governed by the previous rules. So that's what Rena's doing here. So it's a framework governed by the UCR, we're assuming. So the call of contract will also be governed by the UCR. I've put a reminder on the slide that it's Regulation 51 in the UCR that deals with frameworks and awarding under a framework, so she'll need to look at that. And of course, under the UCR, there are no notice requirements when you call off a contract under a framework. So Rena can just go ahead, provided she's within the framework rules, follow the UCR when making that award. And then her third example, she wants advice on making a direct award to a particular supplier. And she's published a VET notice on the 22nd of February. So she got in just before D-Day, the go-live date for the new Act on the 24th. So the transition rules, as I've said, they say commence, and we're looking at when her direct award process commences. It's all about when she first contacted the director for the direct award process, but she's further down the line in this. She's got as far as, well, I intend to award. She's published a week notice about this. So this will be enough to show that she's commenced that direct award process under the old rules, and so lock the old rules in, and it's the old rules she can follow. All right, I'm going to move on now to the next topic, notices. Okay, and we're going to illustrate this with an example based again on direct award, just to follow through this theme. This time the email is from John. He thinks he's got grounds to make a direct award, and that's on the basis that he's buying widgets and competition for widgets doesn't exist. There is only one supplier. He hasn't approached the supplier yet. He's just scoping out his options. But he's picked up on the fact that in the Act there are a number of new notice requirements. So he's asking what notice requirements will he have to follow if he makes this direct award. So he's obviously picked up on the vast array of notices that are required under the Act in certain situations. So we will have to pick our way through this and work out which of these John is going to need to publish when he makes his direct award. So I'm just going to have a little drink of water. Just to say, first of all, when we're talking to John about this, he's really in a three-stage thought process here. He's going to have to satisfy himself that he can direct award, that one of those direct award justifications is available. And as I mentioned, check that his chosen supplier isn't excluded or excludable and deal with all of that. But then assuming that he's okay on all of that, then he's going to have to think about, yes, what are the transparency requirements here? Do I have to observe a standstill period and so on? Just for the sake of completeness, because he mentioned that there's no competition for widgets. So he's probably going to be looking at that paragraph 6 exemption that I mentioned earlier when we were looking at Rena's query, that competition is absent for technical reasons. But let's move on to what the transparency requirements are. So they're illustrated on the slide here. So there are more notice requirements under the Act than would have been the case when you're making a direct award under the previous rules. Most direct awards now require 3 separate notices, except if the contracting authority is a private utility, when only 2 are required. For completeness, I'm aware that I think we've got some local authorities on the line. I want to mention that none of these notice requirements on the slide apply in relation to the direct award of a user choice contract. But for the purposes of today's audience, I think they are most unlikely to be relevant in the district heat sector. So before he makes his direct award, John will need to make sure that the authority publishes a transparency notice. And this is for the purpose of publicising to the market that there's an intention to make a direct award. And the notice includes various details about the contract, the justification for the direct award, and the estimated date on which it will be entered into. Now, just to say that the red box there, having published the transparency notice, if there's a change in a proposal and the authority no longer intends to go ahead with that direct award, then it would need to publish a procurement termination notice. But let's assume that doesn't happen and things are going ahead. After the transparency notice, and crucially now before the contract is entered into, the authority must publish a contract award notice under Section 50 and observe a mandatory 8 working day standstill period under Section 51 before it enters into the contract. So that's a mandatory standstill period, but that standstill period isn't mandatory for a private utility, but a private utility can still observe a standstill on a voluntary basis. And the mandatory standstill period also doesn't apply if the direct award is on grounds of extreme or unavoidable urgency. But probably here for widgets, if there isn't that urgency, then John will need to ensure that the standstill period is complied with. So wait at the standstill period, then provided there hasn't been a challenge during the standstill period, because that would trigger an automatic suspension and prevent the award of the contract for the time being. Provided that hasn't happened, then the authority can then go on to award the contract, but there are more notice requirements then after the contract has been awarded. So they would have to publish a contract details notice within 30 days of entering into the contract. And as well as that, if the estimated value of the contract is more than 5 million, it's also necessary to publish a copy of the contract itself within 90 days. You can redact commercially sensitive information from the contract before you publish it, though. So here, your DHN is owned by the local authority. Well, I'm assuming this one's for DHN. It might not be, but it's in the local authority context. But just for completeness, for a private utility, that this third notice for requirement for the contract details notice and to publish contract, those requirements don't apply to a private utility. So you'll see, as I've illustrated here, hopefully, a marked increase in the transparency requirements for direct awards under the Act compared to the old rules. So under the previous rules, you didn't have to publish any notices in advance of awarding the contract if you didn't want to, although you could publish a VET as a risk protection measure, although you did have to award a contract award notice after the event. But here we've got notice requirements that apply both before and after contract award. And Laura, I'm going to hand back to you now to deal with our final topic.
Thank you, Bethan. So yeah, topic 5, contract management. So here in this example, I'd like you to assume that you work for a supplier, so private sector supplier, and that you're the bid manager for that supplier, and you have a question for your in-house legal department, which is, we're currently competing in a procurement which was advertised recently, so since the Act came into force, and it's for a contract to supply tools and ongoing maintenance services worth 20 million. They have included, the contracting authority has included some challenging KPIs in the draft contract that in reality, I don't think we will be able to meet. We've not been too concerned about performance against KPIs in the past. However, Jane is asking if there's anything new we need to be aware of now. So the key issue here that we're looking at is obligations regarding KPIs and contract management generally. And the key point to note is this is now regulated. It falls within the ambit of the Procurement Act in a way that it really didn't under the previous regime. So let's first have a think about what contracting authorities are required to do under the Act in relation to monitoring and reporting on KPIs. Under section 52.1, where the estimated value of the contract is more than £5 million, including VAT, the contracting authority must set at least 3 KPIs before entering into the contract. So here in our example, we're told that the contract is worth £20 million. So the contracting authority will be under a legal obligation to set at least 3 KPIs in relation to that contract. Those KPIs will be included in the contract between the contracting authority and the supplier. And under section 52.3, all KPIs set must be published. Now, in most cases, the contracting authority will satisfy that obligation by complying with their obligation in section 53.3 to publish a copy of any contract with an estimated value of more than 5 million, although that doesn't apply to Wales devolved authorities. The Procurement Regulations 2024, which support the Procurement Act, require that the contracting authority will need to include a description of the 3 KPIs that are most material to performance of the contract in the contract details notice that is published after entry into the contract. Now, there are some exceptions. So these obligations in relation to the setting and publishing of KPIs do not apply, for example, to frameworks, although they do apply to call-off contracts where those are above 5 million. Also, they don't apply to utilities contracts awarded by a private utility. So how are KPIs assessed? Well, in terms of timing, under section 71(2), contracting authorities must assess the KPIs that they've set at least once in every 12-month period of the contract's life cycle and on termination. They can assess more frequently if they want to. And section 71(2)(b) of the Act and regulation 39 of the procurement regulations say that the authorities must publish information about their assessment of the KPIs in a contract performance notice. And this must include a description of what the contracting authority considers to be the 3 most material KPIs. It must include the contracting authority's assessment of the supplier's performance against those KPIs and the time period to which the contracting authority's assessment applies. So there is an obligation on contracting authorities to assess KPIs at least once in every 12-month period and to publish the outcome of that assessment in a contract performance notice. Again, these assessments and reporting requirements don't apply to private utilities. But let's take a closer look at how performance, at how the KPIs will be assessed. So contracting authorities are required to assess KPIs against the ratings set out in sub-paragraph 5 of the procurement regulations. And a copy of that table containing those ratings is set out on the slide. So a rating of good will be given where the supplier's performance is meeting or exceeding the KPI, and so on, all the way down to inadequate where performance is significantly below. There is a rating of other, where performance does not fall within any of the other 4 descriptions, and there's technical guidance on when you might want to use that rating. So, for example, where there's just no KPI data that has been recorded for that relevant reporting period. So in the light of this, it's obviously important for both authorities and suppliers to consider things like, are the proposed KPIs measurable? How will they be measured? And when will they be measured? Also, are they achievable? Does the contracting authority want or need to negotiate or develop the KPIs with suppliers before they are agreed? And can the supplier suggest any changes to the draft KPIs which will benefit the service itself? So what does this mean for supplier X, who in our example was concerned about whether they could meet these KPIs or not? So what future implications might this have for the supplier? So as we've seen, the failure to meet KPIs, or at least the most material ones, will be published. And that information will be available on the central digital platform, which is available to be viewed by other contracting authorities. So at the very least, there's some embarrassment factor or PR implications from that information being published. It is also possible that failure to meet KPIs could lead to a discretionary exclusion ground arising, which could affect the supplier's ability to participate in future procurements. So it is important to note that failure to meet KPIs is not in itself a discretionary exclusion ground, but the failure to perform a public contract to the contracting authority's satisfaction is a discretionary exclusion ground, subject to certain safeguards. And the technical guidance does make clear that this could include failure to meet a number of KPIs or a certain level of KPI failure. Also, breaches of contract that are sufficiently serious, so if those are breaches that result in termination, damages, or a settlement agreement, are also a discretionary exclusion ground. And it is possible that in some cases, breaches of KPIs could amount to a sufficiently serious breach of contract. And if a discretionary exclusion ground applies and circumstances giving rise to that are continuing when future contracting authorities are looking at awarding contracts or are likely to occur again, then the supplier would be excludable, which it's a discretionary exclusion ground, so they wouldn't have to be excluded, but the possibility for that is there. If a supplier is excludable, then it also gives right to an implied termination right for other contractual authorities who have existing contracts with that supplier to terminate any public contracts they hold with that supplier. So it is fair to say that failure to meet KPIs could have far-reaching consequences for suppliers. In practice, this is likely to depend on the frequency and severity of those failures. So in reality, I don't think that the occasional failure to meet a KPI will have these types of consequences, but the possibility is there. And I think if there are repeat breaches that accumulate over a period of time, or serious breaches of KPIs, then it is possible that supplier X could be in that territory. So in Jane's situation, where she is asking whether it matters whether the KPIs are not met, the short answer is yes, it does matter, certainly more than it did under the old regime. And it may matter a lot depending on the significance of those failures and whether, for example, the contractual authority considers the failure to meet KPIs amounts to a failure to satisfactorily perform the contract or a sufficiently serious breach of contract. So I think the message here for Jane would be try and negotiate on the KPIs if you can. In future procurements, potentially raise them as part of pre-market engagement. And I think from a contractual authority perspective, they would also be wanting to ensure that the KPIs are genuinely achievable, that there is an element of fairness to them, so that the supplier market is not deterred and that your bidding pool isn't unduly narrowed. And also you're going to have to monitor these KPIs and publish your assessment against them as well. So there's a resource implication there as well for contracting authorities. So that brings us to the end of the topics that we were going to cover. So in the last sort of 8 to 10 minutes or so, and Simon, you're coming back in, thank you. I can see you've been helpfully putting questions in the chat. So Simon, do you want to sort of lead on the Q&A section?
Yeah. No, absolutely. Yeah, no, indeed. No, it's very interesting questions. Bethan and Laura, are you happy to take questions about the government's advanced zoning programme project? There's been a couple of questions in the chat. They're very. Would you like to take those offline? They're quite interesting questions.
Yes, certainly. I've seen one of them in particular. So yeah, I can answer that one when we come to it. It's no problem.
Okay.
I can give you such an answer as I have available at this point in time, because we don't know all the ins and outs yet, do we?
Okay. Well, if we start with the one at the bottom from Matthew, Calman's son. So it's under the DESNZ promoted golden share model, where the local procuring authority has a golden share in a heat network XPV, and then that's otherwise owned by a private entity. Does the local procuring authority have public authority oversight under the new Procurement Act? So the local authority only has a golden share. They've procured the private sector partner. Do they have oversight under the Public Procurement Act? Any thoughts on that, Bethan or Laura?
So I go first, Bethan.
You know, sorry, Laura, do you want the answer?
You go.
Okay, I think the answer very much depends on what rights are attached to the owner of the golden share. You know, so typically they will be sort of veto rights or reserved rights, the right to participate in certain strategic decisions, that sort of thing. So I think it's a question of looking at that in the round and seeing whether the golden share gives enough of an input that amounts to public authority oversight. So it's just going to be very dependent on the specific case each time. But certainly I think that there's the possibility that could mean that there's public authority oversight.
Okay.
Would you agree with that, Laura?
Yes, yeah.
Interesting. That's a very interesting response. So maybe something for Matthew to get some detailed advice on, because that could trip up a number of people where authorities are thinking of taking a golden share. If we move up to Barbara's question, topic 1: do social housing associations have to comply with the Procurement Act 23? Are they covered, Laura and Bethan?
Yeah, I can give a short answer to that. Yes. I mean, it was
Good.
always the case under the old rules that they would have been covered, and no change there. And the thinking behind that is that they're heavily regulated organisations. They're regulated, quite closely by the regulator of social housing, and that's enough. I suppose that's public authority oversight. So that, yes, they are contracting authorities.
Okay, brilliant, thanks. The next one up from Lehman, I think it's quite an interesting one. So the contracting body is not owned by the public body, but they supply gas, heat or electricity under Schedule 4. Does the Procurement Act still apply?
Okay.
Yes, so this really comes down to how that body is managed and controlled, and the degree of sort of management oversight really that the public body does have over that entity. So in the example that we looked at in the session, we were looking at a wholly owned subsidiary, but there are certainly subsidiaries that are not necessarily wholly owned that would still be covered. But again, you need to come back to that management and control test. If there's no public body ownership, then you're really having to look at whether it's a private utility, which in this scenario would come down to whether it's operating under a special or exclusive right. And I think at the moment, in terms of the operation of district heat networks, you're probably not at the moment having to operate under a special or exclusive right. So potentially district heat networks that are wholly owned by a private entity would not necessarily be covered by the Procurement Act.
Okay, cool. Thanks very much. The one
And if I can just chip in on, sorry, Simon.
No, go ahead. Go ahead, Bethan.
Just want to chip in on that with a sort of an eye on the future and these new regulations for the zoning. So our current understanding on that is that not only are incumbents going to be given some degree of exclusivity in a corridor around their heat network, but where new operators are awarded a place to operate a network in an advanced zoning program area, they're given exclusivity. I think that's the proposal. So yeah, I think that'll impact on the position as to whether or not they've got special and exclusive right. It may be that will be a special or exclusive right, which then will mean that they are a contracting authority. But I think we need to look at the detail of the regulation when they're available in due course to see exactly how that exclusivity is achieved. But it seems likely that they'll be brought within the concept of contracting authority.
Okay, cool. I don't want to jump around too much, but conscious we've only got a couple of minutes left, and I'm keen to pick out some of the key topics. So there's a question near the top from Mark Easter that he's asked, which relates to KPI, and it's the only one that relates to KPI. So I thought we'd focus on that one. Could the implications for supplier under the KPI poor performance extend to affiliates and or investors of the supplier entity? So how far could the ramifications of poor performance under KPIs go? Does it just stop at the supplier, or are other people pulled into the poor performance of the supplier? Any thoughts on that, Bethan and Laura, or one to take away and consider?
Yeah, it's a really good question, and actually most of the discretionary exclusion grounds do have a sort of wider reach to connected persons of the supplier, so parent companies and sort of direct subsidiaries. The ones relating to breach of contract and poor performance are actually drafted slightly differently and do appear to only relate to the supplier itself. And from memory, there's a bit of a wrinkle there and potentially a bit of a mismatch between the Act and then the regulations, which so the regulations imply that you still have to give all that information about what contracts your connected persons might have breached when you're submitting your information on the central digital platform. So I think, I mean, Mark, you're right to ask the question, and you're right to identify the issue, but in my view, the Act takes precedence, and the Act on these points appear to only be looking at the supplier. The one exception to that is if, as a supplier, you're competing in a public contract, in a procurement process, then you should also be giving this sort of information about your associated person. So those are people that you are relying on to respond to the procurement and deliver the contract. So, for example, a key subcontractor, you would be needing to give that information in respect of them as well.
Okay, brilliant. Thanks very much. Bethan, did you want to add anything, or should we move on to the one final question?
No, I think that perfectly covers it.
Okay, cool, excellent. As we're on a heat network focused webinar, can we just respond finally to Matthew Calmanson's question about AZP? So 2 below the one from Mark Eustace. So if a private sector entity wins a local authority AZP project and sets up the SPV to develop the network, so this is, the SPV is completely separate from the private sector, but it's completely separate from the public sector, but they've been procured by the public sector. Is the SPV exempt from the Act as the AZP project was tendered competitively under Section 6.4b?
Yeah, so I think it's a very, very good question. So it's all the crux of it really is there scope to say that there isn't a special and exclusive right because they won that opportunity fair and square by participating in a competition. And again, I sort of, following what I said in my earlier answer about AZPs, I think we have to see exactly how what the new regulations say around all of this, and on what basis it's established that on what basis the operators are chosen to deliver in the new AZPs. But if there was a competition, I think that probably suggests, if you look at Section 6.4, that wouldn't be seen as a special or exclusive right. Okay. But yeah, we need to see the detail of the regulation. It's all about the interplay between the new regulations under the Energy Act and the procurement rules. And I'm sure they'll have a joined up approach when they're drafting the new regulations. So, but we'll have to wait and see on that. Okay.
Good. That's very helpful. Thanks very much. Okay. Well, we've now reached 11:42, so we will wind it up. We've got people leaving the room, so remains for me to say thanks very much for Laura and Bethan for giving some really excellent presentations on the Procurement Act, and thanks for all the delegates for attending. And thanks for everybody, and please do look out for future webinars for the UKDEA. Thanks very much indeed.
Thank you, everyone.
Thank you.